Solomon in 2001. We were involved in significant restructuring of the businesses for few of the major telecom giants during their pre-IPO restructuring. Then we worked for the restructuring of major electrical giant, major dairy organizations, and so on and so forth. In fact, there were a series of restructuring that I recollect that we started to do between 2001 to 2008. So this restructuring exercise that we have been talking about is not something which is new so far as the Indian corporate structure is concerned. And the emphasis was given to restructuring. It began more since 1991 from the times of liberalization. So I asked this question to myself, what is restructuring? I started to understand that and realized that restructuring will mean a change in the existing structure, either by way of redoing or rearranging the ownership structure, the operational form, the financial restructuring, the business restructuring, or the employee restructuring to make the business viable and robust. So with the increase in competition, the changing business conditions required, and the shareholders also demanded that there be a need for better performance. And that need arose from various factors which were prevalent at different times, including competition, shareholders' demands, and various other needs. So that was the reason why there was a need for restructuring of the businesses in order to be able to adapt to the changing circumstances and environment and to be able to sustain and thrive. So today when we are talking about restructuring, these are the few areas that I'm going to talk about. One is advent of restructuring in India. I've briefly touched upon it. Second is the objectives and scope of restructuring. Why do we need restructuring in the first place? Third is, of course, the procedure for restructuring. There is a set procedure which has been provided for under the Companies Act. We have been following that procedure for a long period of time. The legislative framework that is existing around it. And of course, lastly but not least, is the pre-PAX, which is the new buzz in the town with respect to a restructuring. So I would want to touch upon that subject to the time that is available, because the scope might look like these brief points, but then when you start talking about each of them, they just go on for long. So what is the objective, scope, and procedure for restructuring? The objective for restructuring, as I also mentioned, is enhance the shareholders' value, look for an orderly redirection of the firm's activities, then deploy surplus cash from one business to finance the profitable growth in another, exploit interdependence among the present or the prospective businesses. The other factor could also be risk reduction within the organizations, or the factor could be development of core competencies of the organizations, or sometimes to even obtain tax advantages by merging a loss-making company with a profit-making company, although that is not something which is permitted. But then there are tax advantages that is largely taken into consideration. To have access to better technology, improve corporate performance, to bring it to par with competitors by adopting the radical changes which are brought about because of the information technology, or to become globally competitive. And therefore, the consolidation and the economies of scale are imperative for the expansion and diversion of exploit extended domestic and global markets. Sometimes it is also to increase the market share. And then the restructuring at that point of time, it aims at improving the competitive position of an individual business and maximize its contribution to the corporate objectives. It also aims at exploiting the strategic assets accumulated at a business by the businesses, whether by way of monopolies, whether by way of goodwill, whether by way of exclusivity through licenses, or enhance the competitiveness advantages. So the restructuring helps in various ways, and it brings an edge over the competitors. And in the highly competitive world, where cost cutting and value addition are very important to get highlighted in the objectives of corporate restructuring. So, if we look at the scope of corporate restructuring, what does it entail? It entails enhancing economy, which is cost reduction, I mentioned earlier as well in terms of objectives. It allows to leverage the same to its own advantage by being able to raise larger funds at lower costs. And it also improves efficiency, or I should say profitability, by reducing the cost of capital, which translates into profits. There are various ways in which restructuring happens. One is under the Companies Act, which is the way it has been functioning from the Companies Act of 1913 to the Companies Act of 1956 to the Companies Act 2013. In the present context, it is done under the realm of Section 230 to 232 of the Companies Act. Restructuring is also relevant in today's time under the IBC regime. And the resolution plans that are prepared is basically about the restructuring of the debts of the company. There is also a discussion with respect to pre-packs now, and that is also a form of restructuring of the organization in different manners to be able to enhance the value. The third aspect is by way of resolution of stressed assets in terms of the RBI guidelines of 2018. So, if we look at the present legislative framework, I mentioned that the Companies Act provide for the restructuring of the company under Section 230 and 232. Insolvency and Bankruptcy Code 2016 provides for restructuring by way of either resolution plans or even by way of pre-packs that are now is the buzz of the town. The Competition Act becomes very relevant under the merger control regime for corporate restructuring. And then there are, of course, Income Tax Act, accounting standards, for 𝗕𝗵𝗆 Act, in case there is an involvement of a foreign company or a subsidiary of a foreign company, or intellectual property rights if there are transfer of the trademarks of the copyrights of the transferor company to the transferee company. And then, of course, the Indian Stamp Act 1899, and of course the state stamp acts, which has become applicable for the scheme of mergers and demergers and amalgamations and arrangements. So the scheme of arrangement, the word that has been used, it is a statutory procedure for effecting compromise or arrangement between the company and its shareholders, the company and its creditors, with the sanction of the court. And if we look at the case laws, it suggests that the essence of compromise is that the scheme seeks to resolve some disputes or difficulties or arrangements generally, and it is broad enough to encompass any transaction, whether it is by way of an arrangement between the company and shareholders or a class of shareholders, or it is an arrangement between the company and its creditors and a class of creditors. And it also involves demerger, hiving off of a unit from one company to another. So it entails a give and take kind of a relationship between the company and its members or creditors. So when we, in the earlier regime under the 1956 Companies Act, when the scheme of arrangement were governed under Section 391 to 394 of that act, old act, this legislation lasted for quite a long time, from 1956 to 2013, almost about half a century. And there was a very well developed jurisprudence around the scheme of merger, amalgamation, demerger, or arrangement as such. various judgments under the Old Companies Act. It granted complete clarity on various issues which arose out of the implementation of those schemes. The most landmark judgment that comes to my mind was the case of Mihraj Mafatlal. That was one of the first key cases of 1996, wherein the Supreme Court actually observed that it is the commercial wisdom of the parties to the scheme who have been taken an informed decision about the usefulness and propriety of the scheme by supporting it by requisite majority vote. And that has to be kept in view by the court. The court has neither the expertise nor the jurisdiction to delve deep into the commercial wisdom that was exercised by the creditors and by the members of the company who have ratified the scheme by the requisite majority. So the company court's jurisdiction to that extent was considered in that said judgment to be peripheral and supervisory and not an appellate jurisdiction over the decisions of the shareholders and the creditors. Now, this principle largely continued to be in effect even in the new Act of 2013. And even in the new Act of 2013 under Section 230 and 232 of the Companies Act, the procedures remained the same, the principles remained the same, and the legal precedents that were evolved in the earlier Companies Act continued to find its place even in the new Companies Act and the new company law regime, even for with respect to mergers and amalgamations. So the process more or less remained the same in terms of filing the two motions. The first motion, which comprised of drafting of the scheme, that was the first process. Drafting of the scheme that goes to the board for its approval. The board, upon approval, after holding a board meeting, passes a resolution with respect to approval of the scheme. Once the board has passed the resolution approving the scheme goes to the NCLT, which is called the first motion, along with the memorandum and articles of association, the list of shareholders, the consents of shareholders, if possible, the list of creditors, both secured and unsecured, and the consents, if possible, of both the secured and unsecured creditors. And along with that, of course, the scheme of amalgamation and the balance sheet of the company, both the transfer and the transferee company, along with the requisite fee as per the schedule of fees which is applicable for NCLT. The NCLT in its hearing issues direction with respect to either approving the first motion in case the consents have been duly provided for by the transfer and the transferee company from the shareholders as well as both the classes of creditors, or in case there is no consent which has been provided for either the shareholders or the creditors. In that case, a direction for meeting is given. The meeting is, when the direction for meeting is given under the first motion, thereafter the process for meeting is followed, which is the notice of meeting, which is to be issued. Once the notice of meeting is given to the relevant class of shareholders or creditors for whom the meeting is to be held, the advertisement of the notice is published in the newspapers, both English and Hindi, depending upon the jurisdiction that we are, the registered office of the transfer and transferee company is located. Basically, the concept of the publication is that most people should know about the fact that there is a scheme of amalgamation or arrangement of this nature, which is likely to come into place. And therefore, there is emphasis that there should be publication in one English and one vernacular language newspaper. So it is either Hindi, if it is Hindi belt, or the relevant language newspaper. The notice is also issued to the statutory authorities like the registrar of companies, the income tax authorities, in case it is a listed company, then it also goes to SEBI. And in case it also in fact goes to the Competition Commission of India. And if there are any sectoral regulators, like if it is an insurance company, so IRDA or things like that. So the notice will also be sent to the statutory authorities for their objection. So once the meeting is convened, there is a chairperson, an alternate chairperson who is appointed by the NCLT, who then acts as who acts as the chairperson and vice chairperson of that meeting when the meeting is conducted. The chairperson is responsible for placing the report of the meeting before the tribunal. Once the meeting report is placed by the chairperson before the tribunal, there is a second motion which is called the company petition, which is filed before the tribunal. The company petition will consist of more or less similar documents as was done in the first motion, but along with that, there would also be an additional document which is the chairperson's report. A copy of the chairperson's report is filed along with the second motion. A similar process is followed with respect to the issue of notice to the statutory authorities. And there is a time which is given for the objections by either income tax authority or by ROC or by regional director or by the relevant sector regulators or by SEBI if applicable in case of a listed company. And if there is no objection from any of the corners and the shareholders and creditors have already approved of the scheme of amalgamation or arrangement in the respective meetings, then there is a order which is passed by the tribunal approving the compromise or arrangement which is entailed in the scheme. And then that order, once the certified copy is received, is filed before the registrar of companies. So long and short is the procedure that is provided for is more or less this. This process is followed irrespective of what is the industry we are talking about, which is the sector that we are talking about. The process for restructuring under the Companies Act has been provided for categorically in this manner, and that is how it has been even under the erstwhile Companies Act of 1956. Now, if we talk about the corporate debt restructuring regime or restructuring under the insolvency regime, there are some far-reaching changes which have been made in the IBC code by the Insolvency and Bankruptcy Amendment Act of 2019. With the objective of providing greater clarity on the permissibility of corporate restructuring schemes, which is pursuant to a resolution plan. It upholds the supremacy of financial creditors regarding the distribution of funds proposed by the resolution applicant, and it clarifies the applicability of the resolution plan on all statutory authorities. So by this amendment of 2019, the government added an explanation to the definition of the term resolution plan to clarify resolution plan that would include provisions for restructuring. So section 5 subsection 26 is provided. I mean, this is the definition that has been provided is resolution plan means a plan proposed by resolution applicant for insolvency resolution of the corporate debtor as a going concern in accordance with part 2. So this is the definition which has been provided for, and then similarly the IBPI also via a notification inserted subclause BA in regulation 37 of the Insolvency and Bankruptcy Board of India Insolvency Resolution Process for Corporate Persons 2016 regulation. So even before this amendment was inserted in the code, the provisions for restructuring of the entities in the resolution plan were allowed by the adjudicating authority, which is the NCLT. So in one of the cases of Edelweiss Asset Reconstruction Company versus Synergies Dure Automotive Limited, before the Honorable NCLAT in the company appeal, I think 169 to 173 of 2017, the appellant challenged that merger and amalgamation of the companies cannot be proposed in the resolution plan. And the resolution plan proposed by the Synergy Castings Limited, which was the company for Synergy Dure Automotive Limited, contemplated the merger of Synergy Dure Automotive Limited with Synergy Castings Limited. And it was upheld by the NCLT Hyderabad. The resolution plan approved by the NCLT Hyderabad was challenged on the ground that it was violative of Clause E of subsection 2 of Section 30 of the Code and Section 230 to 232 of the Companies Act 2013. So the tribunal held that the Insolvency and Bankruptcy Code is a code by itself, and Section 238, which provides for overriding effect of it over the provisions of the other acts, if any, of the provisions of an act is in conflict with the provision of INB Act. So therefore, the arguments of the appellant that the merger and amalgamation of the companies cannot be proposed in the resolution plan or such proposal is violative of Clause E of subsection 2 of Section 30 is fit to be rejected. The other issue which came into discussion by the Honorable Tribunal was with respect to interference of courts in voluntary arrangements to assess fairness. So the principle behind the vertical equity is enshrined in Section 30, subsection 2b of the Code. So if we look at Section 30, subsection 2b as amended by the 2019 amendment, it requires that every resolution plan must provide for the payment of debts of operational creditors in such a manner as may be specified by the board, which shall not be less than the amount to be paid to such creditor in the event of a liquidation of the corporate debtor under Section 53, or the amount that would have been paid to such creditors if the amount to be distributed under the resolution plan had been distributed in accordance with the order in priority in subsection 1 of Section 53, whichever is higher. So the NCLAT found this position to be discriminatory in the case of Binani Industries versus Bank of Baroda. There, the NCLAT laid down the principles with respect to taking into account while evaluating a resolution plan that the liabilities of all creditors who are not part of committee of creditors must also be met in the resolution. It also, in fact, gave a finding that the financial creditors can modify the terms of existing liabilities, while other creditors cannot take risk of postponing payment for better future prospects. So that is, the financial creditors can take haircut and can take their dues in future, while the operational creditors need to be paid immediately. The other finding was that a creditor cannot maximize his own interest in view of the moratorium. So if one type of credit is given preferential treatment, the other type of credit will disappear from market. So this will again be against the whole objective of promoting the availability of credit, which is against the essence of INB Code, which aims to balance the interest of all stakeholders, and it does not maximize the value only for financial creditors. So the dues of creditors of operational creditors must get at least similar treatment as compared to the dues of the financial creditors. Now, this position was again enforced in the case of Standard Chartered Bank versus Satish Kumar Gupta, where the NCLAT had observed that though they had noticed a huge discrimination made by the Committee of Creditors in distribution of the proposed amount to the operational creditors, the financial creditors, the majority of the financial creditors have been allowed almost about, in that case, what had happened is that majority of financial creditors had been allowed about 99.19% of their claim amount, whereas 0% was provided for in favor of the operational creditors. So such distribution was not only considered to be discriminatory, but it was also considered to be arbitrary. The NCLAT also held that, in fact, the Section 30, subsection 2, subclause B of the code mandates that the resolution plan must provide for the payment of the debts of operational creditors in such manner as is prescribed by the board, which shall not be less than the amount to be paid to the operational creditors in the event of a liquidation of the corporate debtor under Section 53. This was something which was critically important to have as an observation in order to ensure the safety of the operational creditors who did not have a place in the committee of creditors. So what it meant that the operational creditors should not be paid less than the amount of the corporate debtor, amount that they could have received in the event of a liquidation out of the assets of the corporate debtor. So it does not mean that they should not be provided the amount more than the amount they could have received in the event of a liquidation, which otherwise amount to a discrimination. So the code has defined the resolution plan as a plan for insolvency resolution of a corporate debtor as a going concern. And that is the whole essence of the entire IBC code. And if we look at the regulation 37 of the CIRP regulation, it permits restructuring of a corporate debtor by way of merger or consolidation or sale or transfer of assets of the corporate debtor, which is pursuant to a resolution plan. So, but if the Amendment Act also provides that a resolution plan may also propose restructuring of the corporate debtor, including by way of merger, amalgamation, demerger, thereby clearing all doubts on the possibility of a restructuring of the corporate debtor pursuant to a resolution plan. And if we look at Section 230 of the Companies Act, it also provides for a scheme of corporate debt restructuring, which means a scheme which seeks to restructure or vary the debt obligation of a company towards its creditors. So the scheme process under the Companies Act, it is a very viable alternative to the IBC. First, it is a collective process, a scheme which is approved by the prescribed majority at the meeting of the creditors or each class of the or members or shareholders and is sanctioned by the National Company Law Tribunal. It is binding on the company and all its creditors and shareholders. So the identification and classification of creditors is based on the company's books and the treatment which is proposed in the scheme. And the creditors do not submit proof of claim. And they are not even allowed to classify into operational and financial creditors. So second, it gives creditors the ability to work with the existing management of the distressed companies. Unlike IBC, which is based on a creditor in control model of insolvency resolution, the scheme process is primarily based on the debtor in possession concept or a model. So the directors and the promoters remain in charge of the company, and practically the creditors can consider the proposals without change in the ownership management, except unless it is, of course, the case of fraud or willful default. Thirdly, it is also, I feel that the scheme process can be used effectively to implement the resolution plans which are approved under the stressed assets framework of the Reserve Bank of India, which we will talk a little later. And fourthly, the grounds for review of the schemes by the NCLT are very narrow. So the courts have traditionally examined whether the process and the proposed terms of a scheme on the whole, whether they are fair, whether they are reasonable for all the parties concerned. The fifth aspect that I see is that the process costs are lower than the typical insolvency resolution process cost under the IBC. And the time that it takes is much lesser than the typical insolvency resolution process. So a few alterations to the legal provisions will make the schemes even more efficient for debt restructuring. If we So if we look at some of the judgments in this regard, there have been some interesting findings by the adjudicating authority or NCLT. It has approved the proposal of restructuring of corporate debtor pursuant to the resolution plan. Like, for instance, in the resolution plan for 𝗕𝗵𝗿𝗁𝗃 and Energy, the proposed merger of the special purpose vehicle, which was formed by the resolution applicant with 𝗕𝗵𝗿𝗁𝗃 and Energy Limited, was pursuant to the implementation of a resolution plan. Similarly, in the another case, NCLAT, Vide, it's ordered sometime, I think, in May of 2019, which was arising out of the order of NCLT Bangalore. In the case of MEL Windmills Private Limited versus Mineral Enterprises Limited, it was a scheme of demerger, and it involved a company wherein there were certain pending investigations in respect of mining businesses. The mining business was not being demerged. The company application was made to the Bangalore bench for dispensation of the meetings of the members and creditors. NCLT went into the merits of the scheme and considered the pending investigation and rejected the application. Appeal was made before the NCLAT against the order, and the NCLAT observed that it was manifestly clear at the stage of calling of meeting of creditors for consideration of the scheme of compromise or arrangement by the tribunal, which was not required to examine the merits of the scheme qua the proposed compromise. And any such indulgence on the part of tribunal was falling foul of the provisions which are engrafted in the section 230 of the Act, and it would be without jurisdiction. In the other case that comes to my mind, in the case of Swadesht Oils Private Limited, there was a resolution plan which was approved by the adjudicating authority, and it proposed a scheme of amalgamation of the corporate debtor with the resolution applicant. The resolution plan was approved by the adjudicating authority for Murli Industries Limited, and it contemplated revival of only one undertaking of MIL as a going concern while proposing sale of the remaining two undertakings. So if we look at what is the larger question which emerges, whether a resolution plan which is proposing restructuring of a corporate debtor would need to comply with the merger framework after such resolution plan has been approved by the adjudicating authority in terms of the provisions of the code. Or if we look at the provisions of the code, the resolution plan requires approval of the committee of creditors and then the adjudicating authority. The committee of creditors generally comprises of all the financial creditors of the corporate debtor, and there is no distinction between secured and unsecured financial creditors at the insolvency resolution process stage at least. The resolution plan becomes binding on the corporate debtor as well as the members and creditors, and once it is approved by the adjudicating authority. So in terms of the explanation that has been provided for under section 30 subsection 2 of the code, if any approval of the shareholders is required under the Companies Act or any other law for the time being for the implementation of these actions under the resolution plan, such approval shall be deemed to have been given, and it shall not be a contravention of the Companies Act or the law. And why is that so? That is because there is a concept of deemed consent of shareholders. And the resolution plan being binding upon the creditors, it has been argued, in fact, in many cases, that where the resolution plan contemplates restructuring of the corporate debtor by way of either merger or by way of amalgamation, the corporate debtor should not be required to comply with a separate merger framework as is provided under section 230. So it's a very interesting concept, and there are variant views in this regard. And I think one view also is that the merger framework is independent of the insolvency resolution process, which has been set out under the code, and that the resolution plan cannot be construed as a single window clearance. And therefore, the resolution applicant should comply with the merger framework with respect to the proposals of merger. So there are variant views in this regard, and I'm not getting into the dispute of the various views. And I would rather want to talk about the other aspect of restructuring, which is under the framework for resolution of the stressed assets. So the position before the resolution of the stressed assets under the guidelines of RBI of 2018 is concerned. The framework that existed was with respect to a concept of joint lenders forum. It was a body of banks who had given loan to the entity, and this concept was introduced, I think, in 2011, and thereafter it was revised in 2014. So it's been there for some time. And the assets or the loan of 100 crores or more, which turned out to be stressed, was mentioned as SMA 2. I'll talk about what is SMA 1, 2, 0, and that is as per the framework. So there was a concept of corrective action plan, and the GLF could initiate a rectification, recovery, and restructuring process. There was a proposal for setting up the central repository information on the large credits, and the borrower could request the lenders for the formation of the joint lenders forum. However, after the advent of the code in 2016, RBI withdrew the scheme and the framework upon the enactment of the code. So then thereafter, what came into being is the resolution of stressed assets uh, 2018 guidelines of the RBI. This circular came about in 12th of February 2018, and it set up a new framework for the resolution of stressed assets in the banking system. This framework was set up with the objective of early detection of the stressed assets and to take immediate action thereon, which was synchronized with the IBC code. And with the new framework, all the existing schemes like the corporate debt restructuring scheme or the joint lenders forum or SDR and the SA4A, there were various such schemes which were floated by RBI, were all officially dismantled. So why were they dismantled was because there were not too many fruitful outcomes that came into it. And so far as the bad loans in the banking system was concerned, it kept growing at a very alarming rate. And with that rule, in fact, the NPA recognition was also, it simplified and was done in, then there was more simplification done and more transparency that was brought in. So lenders like all the scheduled commercial banks and all the financial institutions were required to identify the initial stress on the loan accounts immediately on non-payment of debts, whether it is principal or interest or both, for more than 30 days. And these accounts were classified as a special mention accounts, which is SMA, which is based on a number of days overdue. So the early identification key feature that was provided was basically for the stress accounts, which could immediately on non-payment of debt for more than 30 days could be identified. It was monitored weekly and accounts in default with exposure of 5 crores and above, and monthly. And accounts with exposure of 5 crores plus, there was a requirement for reporting of the credit information to the 𝗖𝗺𝗃𝗃 that I mentioned about resolutions. And there was a time-bound manner in which the resolution were to be effected, either through regularization of the accounts or by sale of the exposure by creditors or by restructuring. And in case of the accounts which were for more than 2,000 crores or above, it was to be referred to the IBC. If the resolution plans not implemented within the timeline, then lenders shall file for insolvency application under IBC. So SMA 0 is 1 to 30 days overdue. SMA 2 is 61 to 90 days overdue. That was the concept of SMA. And the monitoring was done by lenders who would report the credit information, including the SMA classification, to the Central Repository of Information, on the CRILC that I mentioned, on all borrower entities having aggregate exposure of more than 5 crores and above on monthly and weekly basis. The process for resolution was that in case of default, all lenders singly or jointly would initiate steps to cure the default by way of a resolution plan in a time-bound manner. And there was a time-bound process which was provided for, where the accounts with an aggregate exposure of 2,000 crores and above as on March 1st, 2018, and thereafter resolution plans were to be implemented with the following timelines. So if there is a default as on the reference date, then 180 days from the reference date, that was the timeline. If in default after the reference date, that is 180 days from the date of first such default. And if a resolution plan is not implemented as per the timeline that is specified, then the lender shall file insolvency application singly or jointly under the IBC within 15 days from the expiry of the set timeline. So for accounts where a resolution plan which involved restructuring and change in ownership, which was to be implemented within a 180 days period, the account should not be in default at any point of time during the specified periods. Failing which, the lenders had the ability or have the right to file an insolvency application either singly or jointly together under IBC within 15 days from the date of such default. The RBI would come out with a similar structure within 2 years for loans with default. Loans with cumulative exposure between 100 crores to 2,000 crores, which was the specified period. from a period which was from the date of implementation of resolution plan up to the date by which at least 20% debt is repaid from the date of implementation of resolution plan. And these periods cannot end before 1 year from the commencement of the first payment of interest or principal or whichever is later on the credit facility with the longest period of moratorium under the terms of resolution plan. So this is what was the concept which was derived at by the RBI under the 2018 guidelines, which was revised subsequently in 2019 with the prudential framework, where there were minor changes which were made with respect to the resolution of stressed assets. Now we are going to talk about the pre-PAX, which is the new block in town. This is another process of restructuring which is being spoken about. It has not found its place in the legislative framework as yet, and there is the recommendation of the Banking Law Reforms Committee, and also, I mean, there are suggestions that in the present COVID times, where we are likely to see a surge of insolvency cases which are likely to be filed before the tribunal, there is going to be a huge increase in the burden of NCLTs, which are already struggling at the moment with the number of cases which have been filed, which was not anticipated. So the government is seriously contemplating introducing the pre-PAX under the scheme of the IBC. Now, what is this pre-PAC? There has been, a very discussion with respect to pre-PAX. What is this? So if the Banking Law Reforms Committee was tasked with contextualizing the IBC, and they recommended a pre-PAX as a viable alternative to the conventional CIRP in India. According to the report which was submitted by the committee, the pre-PAX plan can be allowed under the NCLT supervised scheme of arrangement. And under this arrangement, the pre-PAX plan would be subjected to prior approval of the creditors and the relevant shareholders, or stakeholders rather, I should say, before being presented to the NCLT. So it also provided that the NCLT would approve the stakeholders, would approve the plan only after scrutinizing and ensuring that the plan satisfies the basic requirement as required under the IBC code. And the pre-PAX scheme would essentially follow the procedure which is provided for under IBC, but still preserving the business of the corporate debtor. So in terms of processes, it is much simplified. In terms of timelines, it is much less. In terms of cost, it is more effective. And there are various models of pre-PAX which have come into existence. And these models are globally prevalent. In India, we are still talking about these models and which of these would be the best suited model for the Indian businesses. But globally, these are the three very commonly used models for pre-PAX. One is the pre-PAX insolvency resolution process, pre-arranged insolvency resolution process, and the third is pre-arranged sale. So what is pre-arranged, pre-packaged insolvency resolution process? It is a mechanism for a corporate debtor or a financial creditor may trigger the process by independently appointing an insolvency professional. The insolvency professional so appointed will thereafter invite the plans from the resolution applicants and ensure that the resolution plan offered is the best possible plan in the particular scenario. And all of this happens outside of the jurisdiction of tribunal. This is before we reach the tribunal. And upon submission of the plan received from the resolution applicants, the independently appointed insolvency professional will present the same to the committee of creditors. So there would be a constitution of the committee of creditors as well outside of the tribunal's regime. And the committee of creditors shall approve the plans which will serve the best interest for all. After the resolution plan has been approved by the committee of creditors, the insolvency professional shall file the resolution plan for approval, the approved resolution plan, along with other relevant documentation evidencing the procedural steps that have been undertaken with the adjudicating authority, which is the NCLT. And this will be followed by a public announcement disclosing the details of the pre-packaged insolvency resolution process and the proposed plan, in order to also provide the opportunity to the affected stakeholders or the creditors, or I mean operational creditors, or people who have been left out in the process of deliberation, to object to the proposed prepackaged plan, and upon receiving any objection that may be received after the public announcement, and redress the same. Once there are no objections, or it has been redressed by the adjudicating authority, the adjudicating authority shall approve the plan. So it is also important to understand that such a process is not purely an out of court resolution process, but is a hybrid model where most of the task is taken out of the purview of the tribunal, and thereafter it is only the residual aspect which is brought before the tribunal. The second aspect is pre-arranged insolvency resolution process. This model is suitable in cases where the approval of the resolution plan before approaching the adjudicating authority by the committee of creditors is not possible. So in such model, the resolution plans are invited by the independently appointed insolvency professional, which is similar to the process that was adopted in the pre-packaged insolvency resolution process, which we discussed just now. And upon receipt of the resolution plan from the creditors, the insolvency professional is tasked with identifying the resolution plan which serves the best interest of the creditors and is most likely to be accepted by the committee of creditors as per their professional opinion. The major difference in this model vis-a-vis the earlier model that I spoke about is that in the present model, the insolvency professional is not mandated to get the resolution plan approved by the committee of creditors and can directly provide the best resolution plan to the adjudicating authority by filing the application with it for initiation of formal insolvency proceedings. The third model that also is talked about is the pre-arranged sale model. Now, what is this model? This particular model is most suitable in cases where there exist stringent time constraints. And this model is the fastest mode of resolution of debts. And therefore, it ensures that the value of the assets of the debtor are not harmed and are preserved to the maximum extent possible. In this model, the independently appointed insolvency resolution professional is empowered to sell all or part of the assets without waiting for the approval of the committee of creditors or any adjudicating body, depending on the amount of debt which is owed by the debtor and based on the estimates of the value of the assets as per the insolvency professional's opinion. In this pre-arranged sale model, it is also important that the insolvency professional must determine whether there is a need for a sale at such an initial phase of the resolution. So if the insolvency professional deems to fit to sell all or part of the assets of the debtor, then the insolvency professional must also ensure that the assets are sold to the highest bidder to ensure that creditors recover the maximum possible amount from the debt which is owned by the debtor. So these are the three models which have been propagated worldwide across the globe. And in most jurisdictions, it has found favor in terms of the speed and the time that is taken. There are various advantages of this pre-pack scheme that we are talking about. One is, apart from, of course, preserving the business of the company and protecting it from the potential liquidation, the pre-pack process also, they are very difficult to ignore. One, because they provide a better return to the creditor. And in the present current insolvency mechanism, often during the process of CIRP, the value of assets is getting depreciated because of the time that it takes, and which eventually results in lesser pay to the creditors from the proceeds of the resolution plan. But in the pre-pack mechanism, the value of the assets will get negotiated much in advance, and therefore the time that it takes for the process of adjudication and the time that it takes for the CIRP process to get concluded gets shortened. And therefore it ensures a better return to the creditors. Second aspect that is also advantageous is that it is significantly less time consuming and inexpensive in comparison to the formal insolvency proceedings, because all the essentials of the pre-packs like negotiation, documentation of the proposed plan are done beforehand. So the it reduces the total cost which is involved in the process, and it preserves the value of the business, which can be crucial for the survival of small businesses especially. Prepacks also operate within the fold of the statutory scheme. So, as opposed to a private restructuring process, the prepacks would function as a statutory backed resolution process under the IBC, being a hybrid model, and therefore has will find a more acceptance as compared to the other out of court schemes that or the private restructuring schemes that may be arrived at between the lenders and the corporate debtor. So it would mitigate the threat also of subsequent challenge or non-compliance by the creditors. There are various other challenges and suggestions with respect to implementation of the pre-pack scheme, but I think for today, I guess this is good to talk about, and we will talk for the rest of the issues in relation thereto at our next session. I think if there are any other questions that is prevalent, then I would be happy to take. But my take is that in the kind of pandemic situation that we are in, and the kind of economic slowdown that we are seeing, the economic activities have come to a halt, and the businesses are facing severe financial crunches, and they're pushed into insolvency, and therefore there are newer methods and faster methods and cheaper methods that are considered by the government as well, in order to provide for a resolution of the companies who are suffering at the moment. So I think these pre-packs are a very good concept, which will provide for a time-bound manner of resolution, give the maximized value of assets to the corporate debtor, and of course to the creditors as well, and is going to be largely beneficial for all concerned, including the stakeholders, creditors, promoters, everybody concerned for that matter. So that is all from me. Thank you so much for having me on your in your discussion, and I would be happy to contribute in terms of question answers, or there are any concerns or any other issues. My email ID is already there with you. You can raise questions on mails, or you can ask questions even now. I'll be happy to respond.
Ma'am, we have one question. It's in the Q&A box. So I think this question was asked when you were discussing the statutes and the rules which regulate the restructuring. So the question is, where does the chairperson have to place the report of the meeting?
Okay, the chairperson of the meeting will have to report it to the NCLT. The report is filed to the NCLT by the chairperson after the meeting is concluded with respect to the outcome thereof.
Okay, thank you. So now we have opened the session for Q&A session. If anyone has any queries, please either put them in the chat box or in the Q&A box. We have received comments saying that the session is very informative, ma'am. Thank you so much for giving such a...
I try to pack in a lot of things in terms of information in one session. I thought, these are opportunities where we should try and utilize this opportunity to share our knowledge, information, experience, whatever we have gained over a period of time. So that is the whole idea.
Mitali, I'll be sharing the email ID in the chat box as well.
Right. Yes, I can share the slides with Spurti, and you can access it from there.
Yeah, sure, ma'am, sure. I have put the mail ID in the chat box. If you can, all of you can see that. So, any questions? Are we expecting any questions from you guys? Ma'am, I believe they don't have any queries. It's just the compliments you are getting. So I believe we can end the session. Thank you, ma'am. Thank you for such an insightful and a great session.
Thank,
Really look forwarding to have another session with you. Thank you for your time, ma'am.
thank you. Thanks so much. Take care. Take
Uh,
care, everyone. Bye.